So we all know about the importance of rebutting the opposing party's claims, objecting, denying. Those are affirmative defense according to rules of civic procedure. But one thing a lot of people don't know is that in any given case, criminal or civil, everybody can get it. Literally, actually, anybody and everyone can get it. And that includes the judge. People usually have it in their minds that that man or woman up there speaking in a position of authority is all innocent and clear. No, 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 no. You have to put them in check. And even they let you know. And when you don't do it, it is presumed that you've waived that right. Everyone gets it. This is the reason why you can appoint fiduciaries. This is the reason why you can make the opposing attorney a fiduciary into the case. But that is not what we're speaking of here. This is specific to the judge. Just as the opposing attorney can get it, the judge can get it too. And that is not just limited to reporting them to the lawyer, association of the state or federal, or the Judiciary Inquiry Board or whatever it's called in the state. Or putting in paper trails as preponderance of evidence that, hey, look, you're trespassing against that Constitution which you swore oath to. Beyond that, there's just a little bit of one more step. And it is as simple as every court order. People think court orders are final. Court orders are not final. A judge puts an order for instance, a psychological evaluation. They've seen your track record with other cases or the same case where it's been going on for 2, 3, 4, 5, 6 years. And you've been complacent. You've been condoning what they're doing. And all of a sudden you begin speaking about the Constitution. Oh, something must be wrong with you in the head. Still psychological evaluation. Are you sure you don't want to be our subject? No, you are our subject. Something must be wrong with you in the head. And even if that's not the case, they might do an order such as they try to do an estoppel on you, like a restraining order. And people think, oh no, that's final. Or they put in an order that says, hey, you can't come in as a pro se. Wait, you're coming as a next friend? Wait, you're using other means beyond you just being the defendant? Oh no, we're gonna create orders saying you're not. Oh, you can't do that. People think that's final. No, it's not. And here is a very simple court order that states that, hey, look, this order right here, if you fail to object to it or rebut to it, you waive any right or capacity to bring up any other claims as to the insufficiency or error of this order. Most of us probably already know this, but seeing something in black and white that shows you blatantly puts it into perspective. This is a federal jurisdiction case at Atlanta, Georgia. There's an order by the magistrate judge. And also another thing with this magistrate judge, they need your consent to hear the case. But just to focus on the matter, here's an order by an acting judge. And it says, attached is the report and recommendation of the United States Magistrate Judge in the action, in accordance with, they list their private law. It says each party may file written objections, if any, to the report and recommendation within 14 days of service of this order. This report and recommendation is from the judge. Should objections be filed, they shall specify which particularity the alleged error or errors made, and shall be served upon the opposing party. Service of process. The party filing objections will be responsible for obtaining and filing the transcript of evidentiary hearing for review by the district court. And whenever they say court or they mention the name of the court, they usually refer, this is really the judge acting in the capacity of the court. A party that fails, now this is the important part, a party that fails to object to a magistrate judge's findings, a party, meaning the defendant or the plaintiff, or if you're an interested third party and it has been objected to, a party that fails to object to a magistrate judge's findings or recommendations, the report or recommendation that was served is when they do their, finding of fact and conclusion of laws, they serve it to you. A party that fails to object to a magistrate judge's finding or recommendation contained in a report and recommendation waives the right to challenge on appeal the district court's order based on any factual or legal conclusions in the report and recommendations to which no objections was timely made. And if no objection are filed, the report and the recommendation may be adopted as the order of the district court, and any appeal review of the factual and legal findings will be limited to a plain error review. Save the trouble. Plain error review doesn't mean we don't give a fuck about what you say. We go at our discretion. Look it up if you want. But in layman's term, that's what this means. But you can't say you've not been told that. Right now, this order, we've issued a finding of fact and some other stuff regarding the other things regarding this case of what we think. Remember, it's an opinion. Judges create their opinion. You are the one who bring the fact in. Remember that, based on preponderance of evidence, evidence from the probative value, material facts. You bring that in. The judges create opinions, and you consent to it. That position of trust is always going to be there. Kudos to this judge. He lets you know, hey, look, man, this is what it is. This is what's going on. And if you have yet to catch up, I'm letting you know right now that you can actually object to what I'm telling you. But if you don't, you can't challenge it in the future. Of course, we know, even though in appeal you can bring in newfound evidence or things based on your new knowledge, newly discovered evidence that reasonably you could not have possibly found out in the past. But they're bidding you a step ahead and saying, hey, we're letting you know there's a chance that you probably should object to some of the things that I've done here. So you can't bring up newly found evidence, because guess what the appeal court is going to look at? They're going to look at this order and say, oh, well, the magistrate judge told you clearly there's something you should have objected to because you didn't see it as your problem. You can't claim newfound evidence now. It was right then and there. You didn't read it. It's just 2 pages. Believe it or not, this order is an estoppel. If he does not do something, whoever it is in this case, if they did not do anything regarding this case, they basically barred all their remedies in the future. Magistrates will be honorable and be straightforward with you, like this guy. Some will not. They will just put directed, it is ordered. So in your mind, you're thinking, oh, that's affirmative, that's final. No, it's not. So we know you rebut the complaint, you rebut the response from the attorney or the opposing party. That's basics. But guess what? You can rebut the judge too. Everybody gets it. Everybody gets it. Even if it says an order. Orders can be canceled. Like a money order. You can cancel it. It can be bounced. You can rebut it. You can object to it. It's an affirmative defense. Affirmative defense is not just limited to the other party that's pointing fingers at you. It applies to the judges also. Always remember that.